we're gonna jump into fundamentals of how the Beit Din works, both at the philosophical level and also at the more technical level. Last time we did a philosophical deep dive into the whole historical and hashkafic, perhaps is the appropriate word, background to the whole theme of tzedakah and mishpat, of justice and charity, which are deeply intertwined concepts. So anyone who missed that one, it's kind of a standalone share, so don't worry, you'll be able to follow everything, please God, despite that one being a little bit more on the philosophical side. But
I'll just ask you up front. Now. We've had a lot of shirim that are on Tanakh. In Tanakh, you don't hear a lot of Beit Din or halachic talk in general, as if maybe it was set up perhaps, I don't know, after Ezra. But I have my Avigdor Miller books, which of course is very big on constancy. But we don't see that really. And do you have a thought on that?
Right. I mean, I think that's something that we're going to attempt to do now is to try to really trace the origins of these things from the psukim all the way through contemporary practice. Like again, I'm going to try in these discussions to be as fundamental as possible, and by fundamental I don't mean simple, but rather going back to the origins as far as we possibly can. And in fact, the point that we're going to open up with is going to highlight that. Just for some clarification, the order that we're going to be going through, meaning like the framework that we're going to be using, is in fact the order of the Shulchan Aruch, the last chelik of Shulchan Aruch Choshen Mishpat, which is based on, as we discussed last time, the original work of the Torah that was written in the late 1300s and then used by Rav Yosef Karo in the 1500s as his model for the Shulchan Aruch. So this is going to be the framework that we're going to be using, and frankly, it's a pretty good framework, right? It just makes sense. There's a flow, there's an order to it, so it's a very good map, so to speak, to be able to go through these topics. So let's just jump right in. So the first 29 sections of Shulchan Aruch Choshen Mishpat are the laws of Dayanim, the laws of judges, which go into details of the prerogatives of setting up courts, how the court system functions practically, meaning when people come to the court, what's the procedures that are there, who is valid to be a judge, and the power that the court has in order to be able to execute its judgments. And there are major discrepancies between the powers that the courts had in previous times and the powers that the courts have. And we'll try to address as many of these things as we possibly can. So just opening up. So the most important source in this discussion in terms of the laws of Dayanim is a pasuk in Sefer Devarim that we read just 2 weeks ago. Shoftim v'shotrim titen lecha b'chol sha'arecha. That's a pasuk in Devarim Parak Tes Zayin, which is a commandment. It's a biblical commandment to set up courts. Now, what's important to understand is you might think, okay, so there's like a practical need. People are going to get into arguments. There's going to be need for litigation. There's going to be need for lawsuits, et cetera, et cetera. So you should have courts, in order to be able to address these things. But the mitzvah that the Torah is saying is that there's a prerogative, even if everything is, society is running smoothly and there's no arguments whatsoever. There's no need for an actual litigation. There still needs to be courts that are set up so that there could be a presence of scholars, a presence of the chachamim that are able to also practically be able to address any questions that come up, but that this should be a presence within Jewish society. And what's very fascinating is that the Gemara in Makos and Daf Zayin says there's actually a distinction between Chutz La'aretz and Eretz Yisrael in regards to this commandment. Whereas in Chutz La'aretz, the Gemara says, B'chutz La'aretz chayavim b'chol pelech u'pelech, that in outside the land of Israel, there's a commandment to set up courts in every region, meaning not every single local town needs their own Beit Din per se, right? In every region, there should be general access of the population to a central Beit Din in a region. Okay, so they might need to drive for 3 hours, but in every region there should be a Beit Din. But in the land of Israel, chayavim limnos b'chol ir ve'ir, every single municipality requires, it's a requirement, it's a halachic prerogative to set up a Beit Din in every single municipality. And a municipality could be, it could be like a small little yeshuv with 10 trailers, right? There is an obligation to have a Beit Din in such a place. There's a tshuva of the Rashba, which we'll probably get to in another context, where people ask him, from these far-flung cities in the middle of the Iberian Peninsula, it's like, we don't have a Beit Din. We don't have a Beit Din here, and it's not practical for us to every time we have a question in monetary law to like travel for a week in order to get to Barcelona to ask you every question that comes up. So like, what should we do? And the Rashba gives them various solutions, which are more relevant to the technical topics that we'll get to. But the point I'm trying to highlight here is that the availability of judges with easy access is a huge priority in Torah. The easy, simple access and the general smooth running of Beit Din in general, as we'll see, is a huge principle. And I want to take the opportunity to contrast this. Anyone who's had any experience at all in the secular court systems, either in Israel or outside of Israel, they understand that there's this very strong aspect. I think the most appropriate word is schlepping out. They're schlepping out things. In fact, it seems like they like schlepping it out. Like the half Jewish former president of France, Sarkozy. If you guys remember him, the guy's like a completely corrupt, classical politician. He's been convicted already twice of various stuff. Now they're seeing that he accepted millions of dollars of Gaddafi from Gaddafi back in the day. So they set a court date. To work this out, to work out, how many millions of dollars did he actually take from this Libyan, warlord. So when's the court going to be? 2025, meaning they're planning already now at the end of 2023 for a year and a half from now, we're going to start talking about it, right?
Is that simply because they're overworked?
What, in the French court system?
Yeah.
Right. So indeed, this is a phenomenon. Here in Israel, the average judge, the average secular judge in Israel has 1,000 tikim, 1,000 files on his docket at any given time. 1,000. Yeah. In fact, there's a known thing, and I've heard this from Dayanim personally, that very often, if both litigants are religious and they come to a secular court, which is a problem in and of itself, which we will get to, the very, very severe prohibition of going to secular courts in most cases. We'll talk about this, but if two litigants come to secular court, the judge in Israel will often say, "Why are you here? Why don't you just get this worked out in Beit Din? It'll take you a few days. Here you're gonna get stuck in court. In best case scenario a year, and worst case scenario God knows how long." Like they'll tell them, it's a waste. It's a waste of your time. It's a waste of our time. It's a strain on the system, etc., etc.
So just a question:
the state of Israel was funding the monetary courts, meaning there was a monetary court system from the Rabbanut that was funded by the state. That was changed like a few years back when Ayelet Shaked was the justice minister. But
just to ask, the Torah also tells us to set up a king, but we didn't have a king. So I wonder if it's stronger regarding the courts as opposed to the king. Number one, and number two is take the case of the Geva, the case where they cut up the body in 12 parts, shipped it around, the concubine there. It's clear that there was no courts. Right. As is true for most of the Tanakh stories.
So in Sefer Shoftim, Bruce is bringing up the case, the famous ending story in Sefer Shoftim, which, as all the Mefarshim point out, I believe Chazal already point this out, chronologically, this did not happen at the end of Sefer Shoftim. Rather, it was chosen as the final narrative in Sefer Shoftim to highlight the theme of the book, which is basically everything was bedlam for a few centuries. Until Shmuel came along and started bringing order. Right? What's the most common line in Sefer Shoftim, which repeats itself several times throughout the book? Vayamim ha'hem, in those days, ein melech b'Yisrael. There was no king in the Jewish people. Ish hayashar be'einav. Everyone did what was right in his own eyes. Meaning it was just complete lack of law and order. Now,
so without a king, they couldn't have the courts. Are courts a derivation from the king?
This is what needs to be emphasized. When we talk about courts, what we're mostly talking about are local, relatively small monetary issues. And by relatively small, I don't mean that it's, arguing over 50 shekel versus 1,000 shekel. I mean that they're local issues, meaning they're dealing with two different people. Like, the parties are small scale. The problems that are listed in Sefer Shoftim, are by definition nationwide problems. By definition. And the Pilegesh Begiva incident is the perfect incident to highlight that, because it's an intertribal issue, meaning guys from these Levites, they're in the area of Benjamin, right? So there's like an intertribal dispute. With that, you can't go to a Beit Din. Like, what are you going to do? You're going to sue a guy in the local Beit Din because of what these people in this tribe did that came from out of town. In fact, the Gemara discusses this. It's a very important sugya in the Gemara in Baba Basra on Daf Mem Beis, which Bezrat Hashem will get to, about local courts dealing with an issue that is by definition interstate or intercity. It's a problem. Like, who do you go to? Yeah. So the point of Sefer Shoftim is to highlight that, yes, it's, you can deal with some issues with the Zikanim, with the local elders. Like when the Tanakh talks about Zikanim, the elders, that's what they're referring to. Like, we call it a Beit Din, they call it Zikanim. It's the same thing, right? You can deal with most issues with the Zikanim, but when it comes to national issues, it's not enough. You can't rely on like the local elders council to deal with these large scale issues. So that's what the book of Shoftim is trying to highlight. So back to our discussion over here. Yes, just to highlight the theme of this mitzvah. The theme of this mitzvah is to establish courts that there's going to be this constant access, and the spirit behind this mitzvah is twofold, as we said. First of all, is that this should be a presence within Jewish society. A strong primary, I would say, feature of Jewish society is that there are institutions of chachamim, that they are open, that there's open doors. People can walk in and have immediate access to chachamim. That's the first theme. The second theme is that we want the system of justice to be completely streamlined. In fact, there's a prohibition, which we will get to, we're getting to it now, called Inoi Hadin, which literally means torturing the judgment. Causing delays that are unnecessary. And by unnecessary, I mean anything that's not as quick as possible. Anything that's not as quick as possible is considered Inoi Hadin, torturing the judgment. So this is the first, right? This is the first commandment that we need to understand. Now, the second point that we're going to get to now, which is also talked about in the opening, right, in the opening sections. I'm just gonna read from the Shulchan Aruch, even though this is just a good jumping off point. So in Sif Aleph of Siman Aleph, the Shulchan Aruch opens up with the following statement: Bizman hazeh danim hadayanim dinei hodos v'alvos. In our time, judges are able to judge any case involving loans, uksubas isha, marriage contracts, v'yerushos, and inheritances, umatanos, and any case involving gifts that were given between two parties, v'yerushos, and inheritance, umazike mamon, and any types of monetary damage. Those are the types of things that can be judged in our days. B'chol hakanasos ein danim osam bizman hazeh. All of the fines, the knasot that are listed in the Torah, we are not able to judge in our time. Okay, now last line before we start explaining some of this in more depth. Okay, what are the qualifications for the types of judgments that we can handle in our time? So there's basically three qualifications. Number one is that there is chisaron kis, that there is monetary loss that is suffered from this case. Meaning the guy stole your car, right? The monetary loss is obviously your car. You can judge such a case. Okay.
Why do they limit it like that?
Sorry?
This is the opposite of the Israeli court.
What is the reason why there's this tremendous limitation on the cases that Beit Din can enforce in our day? So in the very first descriptions, in the earliest descriptions of the Torah, that the Torah gives to Beit Din, that we have already in Sefer Shemos. So the Torah says, Ad ha-Elohim yavo dvar shnehem. How is the Beit Din described? It's used with the description of the word Elohim. Now, what is Elohim? Elohim has different connotations. In the first, right, in the opening verse of the Torah, Elohim is used to describe God. And later on, we find that the word Elohim is used to describe a prophet, right? As God says to Moshe, Aaron achicha yeh neviecha, v'hu yeh lecha Elohim, that he will be for you a prophet, meaning Aaron was the prophet of Moses. He was, speaking for him. But here we have a third context in which the word Elohim is used, and that's in the context of a Beit Din. Elohim is used to describe a Beit Din. Now, why is a divine word used to describe a court system, because there is this type of divine authority that is given to a Beit Din. There is an element of a divine authority. Now, what is the process of bestowing this divine authority to a Beit Din? So this process is the institution that the rabbis called smicha. I mean, it's not just the rabbis; it's already the psukim refer to this as smicha.
Is this a
Now,
drush
today,
or is this the pshat? So is this more of a drush? Because I thought Elohim could mean judges, lords, powerful ones. Or would you say that this is just the pshat? What you just said?
No, that's it. I believe this is the pshat. I believe that it dovetails exactly what you just said. The reason that it uses this word to describe judges is because these are people of power and authority. But there are other words that you could use to describe power and authority. This is a word that has a divine connotation. In fact, the very first time that it's used in the Torah, many of the first times, is used to describe God. So the reason that this word using to describe people in authority is a word with a divine connotation, it's because that there is this element of divine authority. Now, getting back to how this divine authority is given over. So we see at the very, very end of Moshe's life, and we're going to get to this right in our Torah portions. So God commands Moshe to hand over the baton to his disciple Yoshua. Now, what's the process of handing over the baton? So, as the pasuk described, ki samach yado alav, because Moshe leaned his hands over Joshua. That's what it says, right? He placed his hands over Joshua, and he leaned over him. Now, what are the two contexts? This is a trivia question for extra points. What are the two contexts in the Torah where we have this commandment of smicha? One of them is this context over here about a master giving authority to his student, and there's one other mitzvah
with the Navi, with Shmuel, and when they pass Nevuah on, doesn't Shmuel lay his hands on Shaul?
Yeah, I think that's basically the same idea.
How about korban? A korban.
By a korban, exactly, by a korban. In both cases, this word smicha is used, which is not a particularly common word, right? Certainly not in the context of mitzvot. To the best of my knowledge, there's no other mitzvah that this word is used in the psukim to describe the obligation of smicha. Smicha. So what is the commonality of this ritual of smicha by sacrifices? That before the sacrifice is slaughtered and its blood put on the altar, and then parts of its body, at least parts, are burnt. What's the similarity between that smicha and the smicha that Moshe gives to his disciple in order to pass the baton over? And all subsequent passings of the baton are also referred to as smicha. In fact, our institution today, we recall, oh yeah, he has smicha from this guy. What's the similarity? So the similarity is
on a supernatural way, you're transferring something spiritual, and in a natural way, you're bonding in a way that.
So I like the idea of transferring. I would say a little bit sharper. Smicha is indicating this is in place of me. This is in place of me. That's what it's signifying. So when a person brings a sacrifice to the temple, and he's saying very powerfully, as the Ramban, the famous Ramban in the beginning of Sefer Vayikra, talking about how experientially a very, very powerful facet of the sacrificial system is that the person is meant to see it's as if he himself is going up to the altar, right? And kind of like a reenactment of of the Yitzchak situation, that he was supposed to be the sacrifice, and in the end an animal was given as a sacrifice. So it's similar to you, like the animal is in place of you. So this act of smicha this is in place of me. So similarly, when the teacher does smicha for his student, what he's saying is, you are in place of me. You are a representative of me. You are in my stead. And that's this powerful act of acting out. The smicha is indicating this. Okay? So this smicha that the Jewish people had, for many centuries, for really millennium, this was an unbroken chain from Moshe Rabbeinu, from teacher to student. Now, when exactly we lost this break in the chain, that's debatable historically, but it was almost certainly somewhere in the early generations of the Amoraim, meaning the early characters that we find in the Gemara, like Rabbi Yochanan, and Rav, people like that. They still had this smicha from the unbroken chain of smicha, which, by the way, we will as we will discuss, smicha can only be transferred in the land of Israel. It can only be done in the land of Israel. So you can go to the land of Israel, get smicha, and go back to your shlichut community in South Africa, but you have to get the smicha in the land of Israel. That's right. That's the rule.
Is that inherent in smicha, or is it trying to convey a message that this transference? They're trying to emphasize Eretz Israel as opposed to something more spooky.
Well, they're trying to emphasize, right. Well, they're trying to emphasize a few things. They're trying to emphasize, first of all, that God gave the Torah to Moshe. Moshe was that very first conduit between God and the people in order to receive the Torah. So any subsequent
which is outside of Eretz Israel,
that's going to have smicha it's going to come directly from Moshe. That's right. That's first of all, and second of all, that the Masorah is inextricably bound with the Jewish people as a nation, and therefore can't be executed outside of the land, because the identity of the Jewish people is inextricably bound to the land. So in order to be able to do that transfer, you need to be, again, in the land. So this smicha, this act of smicha actually gives someone authority. What's the authority that it gives them? It gives them, first and foremost, the authority to judge any monetary case, and that monetary case will be binding. That is the primary authority that is given over in smicha. Now, all the different monetary laws that we find in the Torah, they're, broadly speaking, there are two categories of laws, of monetary laws specifically, two categories of monetary laws that the Torah discusses. And this is an important point to understand because it's very, very fundamental. It's very, very essential. One type of monetary law is referred to in Chazal as mammon, which literally means money. But what that means is that there's the case is triggered by some form of monetary loss, meaning the person has a hard monetary claim on the person. You stole my car, you broke my window, or I lent you money and you didn't give it back. There's actual money, right? There's an actual monetary loss at stake over here. That's dinei mammonos. There's another category which is essentially a form of the penal code. It's a punishment, a knas, or a fine. If I run a red light, I didn't damage anyone necessarily, but when I get the 500 shekel ticket in the mail, that's a form of a punishment. It's a knas. So I didn't hurt anyone monetarily, but I still have to pay because the money is a form of punishment. Now, all these knasot in the Torah, there are many knasot that are listed in the Torah. Many knasot, right? There's the knas, right, of the unmarried woman that is seduced. There's knasot that have to do, right, that are additional layers of punishment on monetary cases. What's a really good example of a knas that's an additional layer on a monetary case? The din of kefel, which everyone is for sure familiar with.
Or stealing the sheep of the cow 4 or 5 times. I mean,
exactly. There you go. According to Torah law, a thief who's caught doesn't just have to return what he stole, but there's a monetary penalty, right? So the default is kefel, double, and with certain items, as Bruce pointed out, you have to pay, right, even 4 or 5 times the amount. So within the same law, within the very law of Geneva, of thievery, there's these two components. There's the component of mammon, of actual monetary loss that needs to be compensated for. And then there's the other layer of the monetary fine. So if there's a case in Beit Din involving theft, that this guy says, you stole this thing that belongs to me, and the guy says, no, actually it's mine, I took it, right? They work it out, and then the Beit Din comes to the conclusion that, yeah, it really belongs to this guy and you stole it. So according to strict Torah law, so the person would have to pay kefel, the person would have to pay double. But the Dayanim today, because we lack this smicha, because we lack this essential authority that was meant to be given over from Moshe to student ad infinitum, because we lack this, it is forbidden to judge any cases involving knasot, involving fines today. So the only category that we deal with in the Torah is this category of mammon, where there is a hard, concrete financial loss.
So how does the court put like a knas on the guy that doesn't want to give a get? Nothing was stolen yet.
Yes.
It's a court case, and I think the Beit Din in Israel has power. I think. Right.
The Beit Din. So we're coming now to a slightly different topic, which is the enforceability, meaning the political authority that stands behind that stands behind the Beit Din. So
Is it the same as in the United States where it's the arbitration versus authority?
I believe that in the United States, it works fundamentally in the same way, at least for monetary cases, meaning the authority that the Beit Din has is the same as a private arbitration law. Anyone that comes to Beit Din today, both parties sign what's called a Ktav Borarut, which is essentially their commitment to follow the psak of the Beit Din. Anyone who comes to Beit Din signs such a document.
So it's an arbitration as opposed to a court where you don't really have a choice once you show up,
Correct.
once you're summoned.
You might not even have a choice to show up or not, meaning you could be dragged there against your will, right? And in theory, the Beit Din of the Torah has such authority, right? They can drag someone there, right? A Beit Din today, when how it's dealt with, if God forbid we have a situation where one of the litigants just refuses to cooperate, right? I mentioned this in the beginning of the discussion that there's a very, very strict prohibition of going to a secular court. And yes, a secular court includes even the secular courts in Israel where the judge is a Jewish man or a Jewish woman. It doesn't matter. There's a very, very strict prohibition of going to a secular court. In fact, the only way in which going to a secular court is permissible is if the other litigant refuses to cooperate. If the other litigant refuses to come to Beit Din, so the person has permission to go and extract what he was damaged from a secular court. And Mizrat Hashem will get to that because that's actually the last siman in Hilchot Dayanim, the laws of secular court. But Bruce is bringing up another question, right? The question of divorce and how we enforce that and the pressure that we can put on a belligerent husband, right? That's not necessarily a question of money. It's not a question of money at all, right? It's not necessarily money in question. In fact, the woman very often she forfeits her ketubah in order to get out of the marriage, in the quickest way possible. So there's really no money at stake. It's just a question of, is the husband cooperating in the ritual aspect, in the isser v'heter aspect of this thing. So in that situation, right, it's not even coming from the force of the Beit Din. There is a law in Israel. There's a law in Israel that pressure can be placed on a husband that is not cooperating in this way. So that is in a nutshell the source of authority that is done today. Obviously, it goes through a Beit Din. The Beit Din needs to conclude that yes, this is right. There's grounds for divorce, and we ordered the husband to give a divorce. And if after that the husband doesn't cooperate, then it goes already. They have powers to put pressure on the husband, take away his driver's license, and even imprison him in certain extreme. Also,
I'm sure you're aware. We had Avram Kowalski yesterday on a Zoom share. He's very opposed to Beit Din in certain monetary matters that he feels that Beit Din is ill-equipped to handle. Futures, for example. There's many categories.
I've actually spoken to Avram Kowalski on this point. He holds that in many aspects the Beit Din is even obsolete. I don't want to put words in his mouth, but that's the impression that I got from him. I've talked to him about this point, and I've argued with him about it. First of all, the courts today that exist in Israel, I'm going to say all courts, I'm saying there are many rishatot, networks of Beit Din, that are extremely, extremely competent and extremely, extremely aware of all of the intricacies of modern business and modern industry, and they really, really do an excellent job. Eretz Chemda, for example, based in Katamon, really, really does an excellent, excellent job. They're all extremely professional. They're all very, very aware of all the intricacies of what's going on. And I think that it's very, very unfair to put that, to paint them all with one brush and say that they don't know what's going on. More towards your point, this is an opportunity to bring in the following halacha. This is a source that I want to quote over here. This is a quote from Rabbi Akiva Eger in his notes on Siman Aleph in Choshen Mishpat, and he brings a tshuva from a chacham of Sfarad known as Ma'arikash. Ma'arikash is a very, very important Sephardi chacham, and he wrote a relatively small book of tshuvot, and he dealt with an interesting case. He had a case where there were socharim, where there were it was like a longshoreman. there was a what's the word I'm looking for? With like the group of a certain profession, like a guild.
A union.
There's a guild of longshoremen. Okay, I hope I'm getting the details right, but the details aren't necessarily so vital to the case. So anyway, there's this guild, and they had a certain agreement between them about how they were going to handle business in the city. So there's going to be a certain volume of business that comes through, and they're going to divide it up in a certain way in order to minimize the competition, to make sure that there's no, strife between the different people. That was their agreement. They all got together and they agreed that they were going to do it. And this was the additional stipulation, which was very interesting. They said, if there's an argument between us about any of these rules that we're making right now, so you all are going to come to our little tribunal over here of like the 3 senior elder longshoremen, and they were going to work it out. That was the stipulation. So basically, what are they saying essentially? We're making our own court. That's basically what they're saying. We're making our own court to litigate our own rules. Okay? Now, obviously, there was an argument, right? There was some argument that ensued shortly after this. Okay? And the 2 litigants, they were arguing, no, this was my client, no, it was your client, etc., etc. And they go to the Beit Din, like 2 good Jews. They go to the Beit Din. They go to the local Beit Din. Okay? And the plaintiff says, listen, we agreed that if there was any argument about these rules over here, we were going to go to our private tribunal. And the defendant says, we're in Beit Din. Beit Din is where you work out your monetary issues. So what do you do? So Ma'arikash says very, very interestingly, he says very, very importantly, that this rule that Beit Din is the sole address for all monetary issues, that is only the last resort. Ideally, this is not what we should be doing. Ideally, people should be working out their disputes in the most peaceful way possible. So if there is localized litigation within the little group that you're in, right, you have committed to working out your argument in that context. And that commitment is binding. And you have to go through it. You have to go with it. There's a very interesting idea. This is jumping ahead a little bit, but it's worth bringing this in, and probably with this we'll end. There's a very important Gemara in Baba Metzia in Daf Ayin Zayin, if I'm not mistaken. The Gemara in Baba Metzia talks about it's talking about the different types of kinyanim. People have the experience with the Gemara; they're probably familiar. There's the kinyan of Hagbah. Excuse me, 1 second. I'm just gonna plug in the computer; it doesn't die on me right at the end. That would be embarrassing. Yeah, there's the kinyan of Hagbah, right? Of lifting up an object. The kinyan of Meshicha, of dragging the object. There's different types of kinyanim that can work to acquire an object. But the Gemara in Bava Metzia talks about this idea of the kinyan situmta. That's the word that it uses in Aramaic, situmta. Now, there's discussion about what exactly this is referring to. Some people say that it's like referring to putting your stamp on an object or something like that. Like, how like they had like those hot irons that they would burn their logo into something, and that would indicate that it belongs to them. But it doesn't really matter what it was, because the point of what the Gemara is saying is that if there is a general consensus that this particular action determines ownership, then that is legally binding. That's what the Gemara says. By the way, and again, I don't want to get onto too many tangents. There's many places, right? There's many holes for tangents over here. But many authorities today say that with online purchases, when a person goes to an item online and clicks on it and says add to cart, and then after he goes to add to cart, he says pay for my order. That is legally binding, even if he hasn't paid for it yet, even if there was no transfer of money, in actuality or digitally. That click of the mouse is legally binding, because that's what it's agreed upon. It's agreed that this action determines the sale, right? So the Gemara already, 1,500 years ago or more, is talking about these ideas, of organically formulated types of kinyanim.
Even though we have the idea of Mashiach, or we have a different concept where money itself doesn't consummate the sale. I thought there's clear halakhic guidelines on how to do it.
Yes, that is true. That is true wait, you're pointing out that money itself doesn't actualize a sale?
Right. I thought if you go to a store, you say, I want to buy this, here's the money, but you didn't actually pick up and move it. You could say, you know what, I changed my mind.
That's correct. That's correct. In Jewish law, if you've only paid for something without making any other acquisition on the thing, then you haven't acquired it. But that's a different.
No, but clicking on the mouse shouldn't effectuate the sale.
That's the action.
Well, but there's no action involved.
No, so you're asking a good question. If there's a tacit agreement, if it's just understood in this area of commerce that transfer of funds already completes the sale, then it should at the very least constitute a situmta. I hear. That's an interesting claim. I have to think about that. But
Israel also has a rule that you can also cancel a deal, I think 12 hours or 24 hours. Something you're allowed to back out. I don't know if that's halakhic, but
consumer protection law.
Right.
Unless other terms are stated at the beginning.
Well, that may be overriding. You may not be able to cancel that.
We're not even getting into the area of Tanai. Tanai, sets of conditions that are determined specifically by the two parties at the outset. That's a whole other area. Like you can stipulate anything that you want at the outset of a deal. You can stipulate whatever you want. We're talking about in the absence of stipulation. We're talking about what's the general default. So the general default can be determined by what is considered normal. What's considered normal in your context. So again, I just wanted to end off at this point. We're already a little bit over time. I just wanted to say, someone asked the Chatam Sofer regarding this Gemara in Bava Metzia. He said, yeah, the rabbi said that you could do, situmta, which basically opens the door for anything. If you make a kinyan by doing 10 jumping jacks, that in theory could, actualize the sale. So he said, is this something that the rabbis made up? Or is it like a real thing? Like, did the rabbis just kind of like invent this idea that anything could be a kinyan? Or is it like a real thing? So the Chatam Sofer answers very, very brilliantly. He says, of course this is a real thing. Of course it's a Torah concept. Of course it's a Torah concept. Why is it a Torah concept? Because the foundation for any sale, for any transfer of ownership, the foundation for that is the agreement of both parties. That's the foundation, right? Regardless of whatever action you take, in the end of the day, the foundation of a transfer of ownership is the agreement of the two parties. And if the two parties decide that what's going to consummate that agreement is some action that they arbitrarily determine, then that's enough. That's enough. This whole idea of Meshicha and Hagbah and all, right, and Masira and all these different things that we know from the Gemara, and there are very intricate laws about these things. What works with Masira, what works with Hagbah, etc., etc. All of these institutions, these are things that Chazal formulated and codified so that there'd be something to work with. But that's not limiting the framework of what works. That's just saying these are tools that can work for most transactions. These things can work. But if you have some other idea that you want to come up with, that's great. And the very fact that you came up with it, that is the foundation for transfer of ownership. So we see that, right? So we see that really, really in a very strong way. And I don't want to sound too extreme, but I really think that this is an authentic way of describing the situation. The entire institution of Beit Din, the entire institution of courts, is really in a way a bidiavad situation. It's really not the ideal. Really, the ideal is that people should come to whatever agreements that they have. They should stipulate the conditions beforehand. They should, if they need to, they should have someone that they're going to, turn to decide, right, to litigate the terms. But to drag two people to court and work out a court case, even in the context of Beit Din, which is extremely sensitive to schlepping out a court case unnecessarily, that's considered a bidiavad. That's considered, a plan B. That's not the ideal.
I think there's a Gemara that suggests you should take a bat, hit the guy in the head, take your bicycle back from him, and then deal with it.
So that is the next siman, which please God we'll get to next week. Siman Bet is the whole question of Adam doesnt la'atzmo. Can a person carry out judgment for himself? Some people would call that vigilantism. However, the Torah is very, very open to this idea of Adam doesnt la'atzmo, of taking what's yours even by force. We're going to see very, very shockingly, you would think, these rabbis, they want you to come ask the rabbi or ask a question, come to Beit Din. No. They were very, very open to people doesnt la'atzmo, of coming and doing judgment for yourself. So we're going to see, please God, next week, we're going to start discussing the parameters of that.
Do we have time for a question? No.
Sure. Yeah.
It's up to Bruce, too. All right. So First, a quick comment. Maslin Bracha is based entirely on that. But anyway, the whole diamond industry, of course, is based on that.
Maslin Bracha and the handshake. Even the Goyim say Maslin Bracha.
Right. So anyway, so my earlier question is that did you say that we can't apply a knas nowadays because of a lack of smicha, but the reason we can is only because of the let's call it the jurisdiction allowed to us by the political authorities?
No, so I think you're confusing 2 points. I was saying that there are knasot, that there are monetary penalties that are levied by the Torah. We gave the example of the kefel, right, of the paying double by the thief. So that can't be extracted at all today. That's just not an area
of the lack of
authority to do.
Because of
the lack of smicha.
So if the government allowed us to do it, which they do in some cases, certain penalties, would the Beit Din then still be would they then be permitted?
This is a good question. The short answer is yes, and the reason for that is because as we're going to find in the Torah, there are really 2 distinct avenues of legal authority. One is the legal authority of the systems of laws that the Torah has dictated, and the other one is the system of laws that are generated by the Malchut, by the Melech being the powers that be. It's a very, very important idea. Please God, we're going to get to it. There are many, many very, very interesting ideas over here. We have a very, very rich literature in the Jewish tradition, very, very rich literature about communities developing their own systems of laws, not in contradiction, God forbid, of the Torah system of laws, but in addition to the stereotypical Choshen Mishpat type laws, there were very, very intricate systems of local laws that were developed by local councils, either the local council of that particular city, sometimes local councils that governed entire regions, entire countries. Right? We have a very, very rich tradition about this, and it's important to know, which is as you can all guess, very important for our current situation. Right? The fact that we have political authority and we have systems of generating laws and rules that govern our society that should not be seen as a contradiction in any way to the system of Beit Din. Now, when there's an outright contradiction between the laws of the state and the laws of the Torah, that obviously puts us in a precarious situation. But that's not what we're talking about. We're talking about where do you set up traffic lights, and are there fines for littering somewhere? Like the Torah doesn't talk about these things explicitly, but it is authority that is given to the community to be able to establish such laws and even extract fines and penalties and enforce them. It's a very important idea. Right?
That's a melech.
Exactly. The Ran in his Drashot, which is his philosophical work that he wrote. He wrote 13 sermons, I guess you could say. Not really sermons. They're really, very complex exegesis on Jewish philosophy. He writes how these 2 distinct forms of authority, the authority of the courts and the authority of the king, they were distinct throughout all of Jewish history. And now that we don't have a melech, much of the authority of the king collapsed into Beit Din. And he gives many examples of that, how throughout Jewish history, throughout the exile, because there was no king, so the authority of the king was kind of placed into the court for many instances. But really, ideally, they should be distinct. The court should deal with the letter of the law as the Torah dictates it, and the king should be that area of governance which thinks creatively how to address whatever problems happen to be affecting society today.
Well, the Ered Mizrach, they had the Reish Galuta. And in certain countries, there's a chief rabbi, the Rambam and his descendants in Egypt.
Right. What did they call the Rambam? And not just the Rambam, but people like him in that position. He had a position called the Nagid. The Nagid. Right. So the Nagid, he wasn't just a rabbinic authority. He was also a political authority. Right. This idea of the meshing of the Torah and the political authority is a very, very. Sorry, what was that?
I said in Morocco, the Rabbanim are paid by the government, by the Moroccan government, and the Jews are not allowed to go to the court in Morocco. They have to go to the rabbinical court.
Wow, fascinating. That's really like the Babylonian model. That the Dayanim had political authority and they had jurisdiction over their community. You couldn't bypass them. Yeah, that's very interesting.
So in your example with the people, I think it was Salonika maybe, or the dock workers. I suppose that any 3 experts can still be convened a Beit Din, even if there's Beit Din in the city.
So again, this is talking about the situation where this is the known norm. This is the known norm about how people function. You can't just make it up one day and say, oh well, instead of going to a Beit Din, we'll go to the panel of 3 experts. That's not okay. Here we're talking about a situation where in the community and in this industry of the longshoremen, it was known that if you operate in this, if you operate in this industry, then you have committed to the rules and regulations of the longshoreman code, right? So you are bound by this, and not only are you bound by it, but you can't go to Beit Din. You can't go to Beit Din.
Was Yitro's advice to Moshe the beginning of Beit Din or the beginning of local councils, or both?
That's a very, very good question. How to understand in this whole discussion that we're talking about now, how to understand Yitro's advice to Moshe, because later on we see that the idea of the elders and the council of elders and the officers, right, the different strata of officers, of 50, of 100, etc. Later on, they're dictated by God. So it kind of seems like Yitro gave over this nice model, and God says, "Yeah, that's a great idea. I think we're going to run with that." It's a very interesting idea. I don't have a definitive answer, and there are multiple approaches to this about how to understand Yitro's advice. I think just at the pshat level, just like examining the psukim, the message of the Yitro story is contrasting Moshe's approach to Yitro's more pragmatic approach, because Moshe was saying, "Listen, I understand that the Torah gives room for courts and other judges, and we're gonna get to the land and set up a whole network of Beit Din. But ideally, if people have a question related to Torah, they should go right to the source. What's the source? Me. I'm the source. I'm God's guy, right? I hear God speak regularly every day. So if people have a question in Torah, they should come directly to the source." And Yitro was like, that's not ideal. You can't have the people, leaning on you all the time, relying for their connection to Torah, to their connection to God, relying on you. You can't do that. You have to let them spread out and be independent. I think at the pshat level, that's the message. Excuse me, the message being delivered. The technicalities of how Beit Din are set up, I don't think that's what the psukim are honing in on over there. That's dealt with later on in the Torah, as we're seeing over here. At the pshat level, it's talking about an approach about Moshe's primacy in the Jewish people's relationship with God, which is a very powerful topic throughout the narrative, but not what we're dealing with right now. Okay. So, Yishar Koach, guys, thank you so much.
We would like to encourage our viewers to share these videos with friends and send in your responses. If you would like to obtain Birkon Nusach Eretz Yisrael or invite the rabbi for a speaking engagement, please email us at office@machonshilo.org.